Hi everyone, I'd like to introduce our keynote speaker, Ms. Eve Hill. She is currently serving as the Senior Counsel to the Assistant Attorney General at the Department of Justice, where she is responsible for oversight of the Division's Disability Rights Enforcement. Prior to that, she was a counsel at Brown, Goldstein & Levy, where she helped lead the firm's disability rights practice. Prior to that, she was Senior Vice President at the Britton Blatt Institute in D.C., in the D.C. office, which is associated with Syracuse University. And prior to that, she was founding director of the D.C. Office of Disability Rights. Prior to that, she was the executive director of the Disability Rights Legal Center in Los Angeles, and was an associate visiting professor of law at Loyola, where she taught disability rights law and special education law. She has served on the California State Bar's Council on Access and Fairness and the ABA's Commission on Mental and Physical Disability Law. She was also the co-chair of the U.S. Access Board's Courthouse Accessibility Advisory Committee, and she is also the co-author of a treatise and casebook on disability civil rights law and policy. And I had the privilege of interning with Eve this past summer at the Britton Blatt Institute in the DC office, and it was very rewarding. She really helped me improve my writing, and she gave me the most substantive work I've ever gotten in an internship. So I would like to introduce Ms. Eve Hill.
Thank you, Eva. Thank you all. Thanks for that introduction, and thanks for not mentioning what a mean boss I am. And I'm really happy to be here today. I'm so happy that also that Deepa was my intern, because that means I get to take credit for her accomplishments for years to come. I can't believe that of all the people you had here just on your agenda today, that you asked me to be the keynote. Are you kidding? Andy Verrado, Kareem Dale, Allison, Nichol, Rebecca Cokley? But I'm so happy to be here. I'm really also thrilled to see the progress that this group has made. Can it only have been 5 years? The original sort of meeting that I participated in slightly was a whole different event than the event that you have now going on. So it doesn't seem possible that you've done this much in 5 years. So bravo to the founders and the visionaries of this organization, and bravo to all the people that have helped make NALSWD continue and grow, and I think we'll have it continuing and growing in the future. Yes. So I just want to make one comment about the last panel, all of whom undersold themselves in ways you cannot believe. There was nothing going to stand in the way of Allison, Nichol, Rebecca Cokley, and Al-Mohamed becoming leaders in this community or any other community they chose to become leaders of. And I learned from them daily or weekly. So don't let them be shy about what they were doing. So I wanted to say that NALSWD really now reminds me of this Margaret Mead quote, which Allison can testify is about the only thing I have on the wall in my office. And it says, "Never doubt that a small group of thoughtful, committed citizens can change the world. Indeed, it is the only thing that ever has." And that's what this group is doing. My speech is going to be a little bit all over the place because I want to talk about so many things. And that Margaret Mead quote is probably as deep as it's going to get. I want to talk, and you had wine, so that might be okay. I want to talk about jobs for students with disabilities. I want to talk about what DOJ is doing in the disability rights field, because that's why I came here and why I'm so excited to be working at the Justice Department. And I want to talk a little bit about what NALSWD, I think, brings to the legal community and why it's so essential that it continue and grow. And I really then, if we have time, I'd really like to talk with you. I'd really like to hear from you about questions that you want answered. I may or may not be able to answer them because I may or may not be able to answer them. So let's talk about jobs. I know you've been hearing about employment in different sectors all day. And really, you could have canceled the whole thing because I've done all those jobs. And I'm not joking. I think employment is really, really, really important. So I don't want to leave it off. And I've done private firm, government, nonprofit, academic, bank teller, waitress, computer programmer. So my tale of my employment history is probably a cautionary tale. But I did come up with 10 lessons that I learned from these jobs. Please don't write them down. I grew up in Maine, about half an hour outside the middle of nowhere. We were very poor. We got food stamps. Once a month was the greatest day of the month because you got to go buy food. Twinkies were the thing. You could get those with food stamps. You may not be able to in the future, I hear. And it was I had a mixed-race family, and so we were different. But we were poor, and everybody else around us was poor, so we didn't notice. I actually thought I was middle class. I guess I didn't watch enough television. So I thought I would be a secretary, because my mother was a waitress and my father was a carpenter, and so secretary seemed like a step up. I could wear a dress to work, and I could sit and not run food to people, and people probably wouldn't yell at me so much, and I'd get a regular salary and not have to work for tips. So that was my plan. Boy, did that plan go wrong. I went to college because studying was fun, studying was good, I was good at it, and the college paid for it. That was the only way that was going to happen. And I went to law school because I got towards the end of college with an English degree and thought, ooh, I'm going to have to be a teacher. That's not going to work for me. There's this test, the LSAT, I'll take that. And I did really well in the LSAT. So thank goodness I'm good at standardized testing. So not a planner, I would say. And I went to law school. And they paid for it too. So again, it wasn't going to happen without scholarships. When I graduated from law school, I wanted to do civil rights. I had never heard of disability rights. In fact, the ADA hadn't been passed yet. Yes, I am old enough that the ADA hadn't been passed yet. Many of you probably can't identify with that possibility at all. And they didn't teach Section 504 at my law school. So I was thinking women's rights, traditional civil rights, but I didn't have any money. And I didn't have loans. So I joined a private law firm, and we did natural gas contract litigation. This is your dream job. And I'm not going to argue with you about that because it leads directly to a civil rights practice. And apparently it can. And I liked it. I didn't care who won most of my cases in a deep personal way, but I wasn't doing anything evil, and I was good at it. I got to figure out big, complicated legal issues. I got to know everything about res judicata for a while. I know you probably don't think that's exciting, but I knew everything about it, and I could work it into sentences that you could not believe. You could turn it into cocktail banter, I'm not kidding. So I got to research and write the most beautiful briefs, including 3 Supreme Court briefs, and there's nothing wrong with that. I got to work on multi-million-dollar trials. I got to do my own case. And so I was happy, but I wasn't inspired. And so I started doing volunteer mediation on the side as a free mediator, as a pro bono project, and that was eye-opening. And then I took a training for pro bono lawyers on the ADA, which had just been passed. And my teacher was Hy Feldblum, who you're going to hear from tomorrow. I am so lucky. Who gets that? And so that was amazing. And then DOJ, like weeks after I take the ADA training, starts advertising that they're gearing up their ADA enforcement. And here I am. I know something about the ADA, and it turns out they want to create a mediation program. So, ta-da! Lesson 1. Do your job all day and do what you love for free in your spare time. because then maybe you'll be qualified for someone to pay you to do what you love. And that's what happened to me. No guarantees, except it is pretty much guaranteed that if you don't do what you love, you will never be qualified to get paid to do it. Lesson 2, your first job doesn't determine your career. So, work, learn, experience, and then turn it into what you would rather do. So I got to work at the Justice Department Disability Rights section for 5 years. I started the ADA mediation program. I started the building code certification program. Again, everybody wanted that one. And then I ran the investigations unit. So I'm kidding. These were not the jobs that most DOJ lawyers wanted. They wanted the sexy litigation jobs. But it was great. I learned so much. I learned everything I thought about the ADA. It changed my perspective on the world. I helped to shape the law. I got to help change the world for the better. So lesson 3, try things you don't know. Try things you don't know if you'll like. Building code certification may be really interesting, and it is. And do the scary things. I told Allison just the other day, jump off the ledge, and once you jump off the ledge, you might as well do a backflip. Do the scary things. So, lesson 4, take a mediation class. Even if you're not going to mediate, mediation, the skills you learn there are really powerful. They teach you how to negotiate, and even, this is not very mediator-like, but they teach you how to manipulate people. Want to get your spouse to take out the trash? Mediation skills. And you don't have to do the sexiest project. I think Allison said this. Do what needs to be done. Sign up. Do it enthusiastically. Do it well. Bing. You are essential. And you'll get some of the sexy projects. So then I moved to Los Angeles and took over what would become the Disability Rights Legal Center. And Paula Perlman spoke earlier about that. That's a nonprofit organization that does high-impact disability rights litigation, special education advocacy, advocacy for people with cancer, and a variety of different things that are all moving the disability rights movement forward in Southern California and beyond. And the DRLC is located at Loyola Law School, so I got to teach. Yet another great job. I'm really lucky. I worked with a great team of people, and we grew the DRLC into an even more amazing organization. And teaching at Loyola, as well as working with the Loyola extern, introduced me to law students with and without disabilities who taught me more than I taught them. Don't tell them that. Don't tell the law school that. They taught me about how people learn and about how people get inspired to take action. And they taught me how many different ways there are to be a lawyer and to make change in the world. I also learned how valuable it is to train the people who are on the opposite side from you or who are going to be on the opposite side from you. There is really very little less powerful than walking into a negotiation where your former student is on the other side. Because you know, they already know there's a problem here, and they're ready to start fixing it. So, lesson 6. Changing the world is really fun. Do it. And teaching is really hard, and you're doing it whenever people are watching you. You're not just doing it when you're standing in front of a podium and people are drinking their wine. You're doing it all the time, and it really pays off. So think about the fact that you're teaching people when you're talking to them. In California, I also learned about working in coalition with the whole community. So we worked with disability advocates, of course, and we all were working together, mostly all in the same direction for the same goals. But we also worked with anti-poverty advocates. We worked with language access advocates. We worked with healthcare advocates. We worked with everybody. And that allowed us to amplify our message in communities that would otherwise have never thought about disability rights as an issue that they should care about. And it got us to legislators and leaders and others who did not care about disability rights, but who saw now the connection to an issue that they did care about. So it got disability rights out of its niche market and into the broader world. So lesson 8 is get out of your box, get into other people's boxes. then they're carrying your message around for you. But you can't stay in sunny California forever. Well, maybe you can, but I couldn't. I came back to DC and repeated the whole cycle at higher speed. Government, boom, DC Government Office of Disability Rights. Academia, Burton Blatt Institute, Syracuse University. Private firm, Brown, Goldstein, and Levy. Woo! And now back to DOJ, but in a leadership position. So lesson 9 is different. Lesson 9 is, who needs money? But that's a laugh line, but I'm serious. If you're going to do it just for the money, you should be worried. I would be worried. If I did things just for the money, I would be worried. That I better be finding something outside of my job that's going to make me really happy. Money's not bad, mind you. Or how would I know? Maybe money's bad. Lesson 5. Learn, 9.5. I had to slip in a middle one here. Learn to interview. So clearly to do all these jobs, I had to be pretty good at interviewing. I like interviewing. It's somebody asking me questions about me. I'm the spotlight. Love to talk about me. And if you start to think about it not as this dreaded, horrible thing where they might reject you, and start to think about it as you really don't have anything to lose. You walked in without this job. The worst thing that can happen is that you're going to walk out without this job. Perfectly even. They can't, as my father always said, they can't kill you and eat you. Cannibalism is against the law. So then, why are we working? When you ask a lot of advocates what they enjoy about their jobs, they'll say, I enjoy making a difference in people's lives. And they may mean, I enjoy making a difference in the world in general, and they may mean, I enjoy making a difference in my clients' lives. And that's true. But that's a little abstract for me. I feel that like once a month or once every few months, that something important has moved forward in the world because of something I did. And I have a short attention span. I need to do something that I enjoy at least once a week. So I'm really tangible about what I enjoy and what I need to make sure is going to be available to me in whatever job I take. Your work isn't just your contribution to the world. It's also where you go every day and what you spend a lot of your time doing and what you take a lot of your self-worth home with. So I encourage people to think about something more tangible. For me, it's writing. I like to write. Give me a pen and a piece of paper with lines on it, and I can write something, and that will be helpful to me. For some of you, it may be getting in an argument, making your argument. So try to find jobs that give you that kind of opportunity. For some people, it may be figuring out a problem. So make sure you get to do research and figure out a problem. Some people need to interact with people. So look for things where you get to interact with the client, where your colleagues are around and having a mix with you. Some people do not. Look for a place where you can close your door. This part is important. People laugh at me. This part is important. You can change jobs, you learn new skills, but you can't change who you are. Maybe eventually you can. But you might as well feed the piece of you that's going to be made happy, particularly by a simple thing like a pen and a piece of paper and an opportunity to write something. So think about what you like to do in your job and try to do it. So lesson 10, make sure your job involves something tangible that you like to do. I'm sure that's cleared it all up for you. You will now know exactly what job you want. I'm pretty sure it's advertised on USA Jobs, almost in exactly these ways. But now I'm going to talk about DOJ. I'd be letting down my employer if I didn't tell you about the amazing work that made me come to DOJ and that makes me, in addition to my pen and lined paper, willing to get out of bed in the morning and go fight for it all day. So DOJ is really energized to do disability rights work. Disability discrimination is sadly alive and well in this world. Allison Nichol and the Disability Rights section and the Special Litigation section and I take on flat-out, obvious discrimination every day of the week. So like the Montessori school that would not accept a 5-year-old with autism, and the department's settlement agreement required the school to adopt non-discrimination and reasonable modification policies and pay the parent monetary compensation. Like Wells Fargo Bank refusing to accept relay calls from customers who were deaf, and DOJ's settlement required the bank to adopt effective communication policies and provide $16 million in monetary relief for customers nationwide. 20 years after the enactment of the ADA, we still regularly investigate and resolve refusals by hospitals and other entities to provide sign language interpreters or other auxiliary aids and services. We just settled one with the Henry Ford Health System that had denied an interpreter to a person throughout a 30-day residential program. How much do you think you get out of a 30-day residential program when you don't get to talk to your treating physicians? People with HIV continue to be denied access to everything from swimming pools to their chosen occupation, to the licensing for their chosen occupation, to laser hair removal, to medical procedures. DOJ took on all these types of discrimination and more, and has created a website specifically dedicated to HIV/AIDS discrimination. New buildings are still being built inaccessibly. We filed a statement of interest in Colorado Cross Disability Coalition versus Abercrombie and Fitch litigation because Hollister stores, you may have seen them in the mall, are routinely built with a front porch entrance that has steps up to the front porch and then steps down into the store. That's not accessible. And it's purely for decorative reasons. In the last 6 months, we've settled over 15 over-the-road bus companies that had no wheelchair-accessible buses and no ability to serve people with disabilities. And in our Title I enforcement role, we recently reached a settlement with the Illinois State Police, which had been automatically excluding from cadet positions anyone who used a hearing aid or an insulin pump. And we've reached agreements with about a dozen city and county governments a year through our Project Civic Access compliance reviews. And those settlements address access to every aspect of civic life in those towns, cities, and counties. Our new Title II and Title III regulations came out in 2010, and many parts became effective in March 2011. The last pieces, mostly regarding changes to the accessibility standards, will become effective next week, Thursday to be precise. And we're also taking on discrimination in the education area, an area near and dear to my heart, because it's the beginning. It's how we get law students with disabilities, right? We filed an amicus brief challenging a public school's decision to place a student with diabetes in a school other than his neighborhood school based on his use of insulin. We filed a statement of interest challenging a public school's refusal to allow a 7-year-old with autism to use his service dog in school. We reached a settlement agreement with a nationwide network of private schools, the Nobel Learning Centers, to stop their discriminatory practice of excluding students with autism. We're taking on testing. We recently issued regulations that make clear that when a testing entity needs documentation of disability, that documentation request has to be reasonable and limited to the need for the modification being requested. They don't get your whole medical history. Generally, a testing entity should accept without further inquiry documentation provided by a qualified professional who's made an individualized assessment. And testing entities have to give considerable weight to documentation of past accommodations in similar testing situations or in an IEP. Testing entities also have to respond in a timely manner to the request for testing accommodations. So we shouldn't be getting, we got your documentation 8 months ago and we're going to tell you it's inadequate the day before the exam. And we're not leaving out law students. The Minnesota U.S. Attorney's Office recently reached a settlement with the LSAC, requiring them to allow a student with hypotonia, ADD, and learning disabilities to take the LSAT with a variety of accommodations, applying the standard to best ensure that the test reflected his knowledge rather than his disability. As some of you know, best ensure has been something they did not. DOJ also reached a settlement agreement with LSIC, requiring them to make their online law school admissions application accessible. And DOJ filed a statement of interest making clear that the National Conference of Bar Examiners is required to apply the best insured standard when determining what testing accommodations to provide for the MPRE. So you may also have heard about our Olmstead enforcement work. DOJ is really committed to the civil rights principle of community inclusion of people with disabilities. The ADA requires state and local governments to provide services for people with disabilities in their communities. And Olmstead has been called the Brown versus Board of Education of the disability rights movement because it says that separate isn't equal and segregation is discrimination. I'm proud to say that DOJ and disability advocates and lawyers across the country are confronting the institutional systems that segregate people with disabilities from their communities. This principle so far has mostly been enforced in the context in which it originally arose: health services for people with mental health conditions and developmental disabilities. This enforcement recognizes that for these people, society has long relied on institutional settings like psychiatric hospitals, DD centers, and others as the only places where mental health services and developmental disability services would be provided. You had to go there and be segregated and interact only with other people with disabilities, or you had to go without. That assumption is based on the idea that people with mental health conditions and developmental disabilities are not capable of living in, benefiting from, and contributing to the outside community. So they had to be protected from us, and we had to be protected from them. It was also assumed that it would be cheaper if we took everybody, clumped them all together, and served them all in one place. So now we know better. At first, the cost assumption is wrong. Community-based services are generally less expensive than institutional ones. And we can serve just about everybody, no matter how complicated their needs, in the community. Second, we know that people with disabilities benefit from community inclusion. Community involvement helps people with disabilities avoid learned helplessness, stimulates intellectual growth, develops social skills, and increases self-esteem. This shouldn't surprise us. A person learns to live in the community by living in the community. We all need supports: family, friends, guides, maps, Google, Facebook. But we don't learn the community by staying in our room. And neither do people with mental health and developmental disabilities. And integration of people with disabilities also helps the community. The community members learn tolerance of difference. They learn to improve their communication skills. They learn patience, and they learn to benefit from the diversity of the experiences of others. So through our Olmstead enforcement, we're transforming state service systems that relied on big institutions into service systems that focus on providing services in a person's home, whether it's their own home, their family's home, or a small group with a small group of roommates. We've reached transformative settlement agreements with the states of Georgia, Delaware, and Virginia. Under these agreements, states have to develop community-based services and transition people out of institutions. We've also issued letters of finding, identifying Olmstead violations in North Carolina, New Hampshire, and Mississippi, and we've opened investigations into a bunch of other states. At first, our work focused on where people live. But community integration doesn't end at the apartment door. The fact that a person sleeps in the community at night will not mean much if they spend their days in an institution. At one of the meetings to discuss the Virginia settlement with members of the community, a woman with developmental disabilities stood up and said she lives in her own apartment, but the store owner at the 7-Eleven down the street wouldn't let her in to go buy groceries. And that's Olmstead next. Yes, we've gotten you out of the institution, and you need to be able to benefit from all the things that your community offers. And so Olmstead integration and ADA enforcement don't stop at getting you out of the institution. But also, we're now applying the community integration lens to other areas of life. School. Are the students still getting on the little yellow bus and going to a separate school? That's not integration. Are funding programs leading to greater disability-only classes? That's not integration. Work. Are people being placed in sheltered workshops unnecessarily? That's not integration. And day programs. Are people being sent to day hab programs where there's no one but a person with, but other people with disabilities there? That's not integration. I could go on. I must say, all this great stuff is not mine. I didn't do any of it. I just got here. This is all Allison's crew and the DOJ lawyers, some of which may have been here today, and the amazing work that they do, and the really visionary ability they have to see where this is going and anticipate and get in front of the problems. So I'm very proud of that work, even though I didn't do it. But wait, there will be more things, and I'll claim them as mine. So a little bit further on the theme of community, this is about NALSWD and the legal community. I was thinking about back in 2007, when I was talking to Brett about it, why did I think this was important? And so I looked at your description on the website. NALSWD is a coalition of law students dedicated to disability advocacy and the achievement of equal access, inclusion, diversity, and non-discrimination in legal education and in the legal profession. NALSWD aims to support the growing number of law students with disabilities by providing a safe and supportive community to connect with other students with disabilities from across the country, networking with lawyers with disabilities, information about career opportunities, and advice on succeeding in law school and the legal profession. The success of NALSWD as an organization depends on the active participation of law students with disabilities. When I first started talking to folks as this was being formed, it struck me and still strikes me as a way of creating community for people with disabilities in the legal education forum, in a community where finding your own community is hard. I have a mood disorder. It wasn't diagnosed until I was 30, so it wouldn't have helped me in law school to have NALSWD, but if I had known earlier about myself, it would have helped me in law school. Some of the issues that people face are, do I disclose? How do you bring this up in the conversation? And what do you do when the person that you thought you knew makes that face? Really? And are we really entitled to claim the title of disability? Are we disabled enough? Are we entitled to be part of that group? All those things are things that NALSWD can help people work through. Do you tell your employer? At what point do you tell your employer? When you need an accommodation or before? All these things are things that can help individual law students navigate the types of questions that are going to come up as they move into the legal community and even the legal education community. But NALSWD could also be important because it brings committed, talented lawyers into the cause of disability rights. One of my favorites, we need more committed, talented lawyers in the disability rights field. But to do that, you don't really need a group of law students with disabilities. We need a group of law students with and without disabilities who care about disability rights. A junior version of the Disability Rights Bar Association. And this is specifically a group of law students with disabilities who may or may not be interested in disability law. Although it's a great career, don't get me wrong. But I'm not saying you should all be disability rights lawyers. We should infiltrate. We should be everywhere. But you wouldn't say that any more than you would say that women should all do women's rights work and African Americans should all do civil rights work and so forth and so on. So what if NALSWD is a career network? We're all going to help each other find jobs, or maybe you're like a social club or a fraternity. But I don't think so. Your description doesn't indicate that, and there's really not enough drinking going on. I hope you're a community for people with disabilities within the legal community. I hope that you can open up the law school community to make it safe for students with disabilities. Just as women and minorities did before you, you challenge educators to reconsider who can really be a lawyer. You also challenge them to examine their assumptions about how people learn, how people demonstrate their knowledge, how people practice law, and what's really important to be a successful lawyer. Chris Griffin used to talk about an example where a law firm said, well, we don't know if you can hire you because of how you get the books down. Well, that might not be the most important thing about being a lawyer. And you all are going to challenge your law schools to reconsider whether that's the most important thing about being a lawyer. I hope that opening up the law school community will, in turn, influence bar examiners and law firms and courts and so on. And that will knock down some of the assumptions about whether we can even be lawyers. And I hope that having us in the profession that advocates for justice most of the time, some of the time anyway, will start to challenge the world's unjust and unfair beliefs and assumptions about people with disabilities, about us, about our clients, about others with disabilities. Maybe we could get there just by showing up. So all of us, we don't really have to have an association or a community or a group. We're all just going to be there, and people will figure out, oh yeah, that person has a disability, so people with disabilities must be able to do more than I thought they could. But I wouldn't count on it. I'm not sure we'd have gotten the ADA without a disability community that came together. There were 54 million of us before the ADA came. And just having that count didn't get us the ADA. We had to work together, come together as a group, reverberate each other's messages, identify what were the core issues for us. We, people with disabilities, probably aren't as strong advocates alone as we are in a group, or at least when we know we've got somebody that's got our back, as Rebecca said earlier. We amplify what each other says. We push each other forward. I sometimes hate that. Don't be pushing me forward. You go forward. And we support each other. We test each other and help focus our messages. I don't always like that process either. And we hold each other accountable. And if we don't think through these issues about disability community and disability culture and who's in and who's out, who will? So, those are some of the things that I hope for NALSWD. And I hope, more importantly, less importantly, that I'll be able to help in a little tiny small way so that for years to come, I'll be able to claim your achievements too. So, do we have any time left? Yeah. Okay. I would really like to talk to you all. Questions, concerns, tell me what I said that was so wrong you can't believe it. I can take it. Yes?
I loved what you talked about, more of what NALSWD can do in the future, and we're certainly always thinking about expanding our advocacy efforts and things like that. Do you have any suggestions for us as, well, a little more context, we're also going to probably be joining as a nonprofit soon and joining with an association of lawyers with disabilities, but how can law students specifically kind of, while we're in law school and have all these other things, become more active and become a stronger, greater organization?
Well, I don't know. A bunch of different things. For one thing, you're in the legal education community. You are on the ground, able to see what the problems are that are barriers to people getting in, that are barriers to people succeeding, and that are barriers to people moving on to the next step. So bringing those things to the lawyers who can take them forward is really important. Bringing them to the Justice Department, bringing them to the Disability Rights Bar Association, or the lawyers in your communities who can do them, and particularly bringing them in a way that shows that it's not just me, it's us to whom this is a barrier. And thinking about, very often we'll be able to say, well, I need this thing and they won't give it to me. And that's a sort of one case. If we can think about what is their bigger motivation for not giving it to me, we can take broader cases that can apply to more things. So they won't give me double time because they think because they think extra time is like cheating. So how can we bring cases that challenge that? Or how can we do research or surveys that challenge that? So if you start to figure out what the underlying motivations are, we can start to bring better approaches to challenge the underlying motivations. And that does a domino effect. Just one. Yes?
When you talked about underlying motivations, I know one thing that I've often heard, it's a two-part thing that you often hear. One, accommodating people with disabilities is expensive. It costs money, which is always a fight that you hear, especially during times of budget crisis. And the second thing that I've often heard is that a particular thing, whatever it may be, is in compliance with the law, and although that may be true, maybe it's not practical. You know, whoever writes the laws isn't necessarily on the ground living, a certain way. So something may be practical or not practical, but in compliance. And I guess my question would be, what do you say to that? Where yes, it's in compliance, but no, it's not practical. Or how do you bring that?
One idea is I'm going to be your donor one day, but only if you get me through the graduation process. But I think the money piece is one thing. It's kind of a legal argument about what the money piece is, but it's not how much am I costing you versus how much is my tuition. Although pretty much that balance is going to weigh in favor of providing the accommodation a lot. But it's how much is my accommodation costing you versus how much money you have in, for example, your endowment. And so looking beyond I think it's just too much expense or it's just a little too annoying for me to provide, that's not the end of the question. For the more, it's not practical, it doesn't work, but it's in compliance with the law. I'm a disability rights lawyer. I'm a little stuck with how it complies with the law. And I have a little trouble getting around that. So I can't advise you on that, but there are people who can. There are people who figure out, how to nag and how to cajole and how to be charming. Also not one of my best skills. So find those people. There are people in the world, some of them I met in those mediation classes, who can get you to do anything. And so find some of those people and have them get you the things people could get are shocking. So it doesn't have to be always the legal fight. It can be this is what's right and this is what'll get you, or it could be, I don't know, these people have magic. They sprinkle fairy dust and people go, oh, okay, sure, I'll give you what you want. Not the best answer, but I can't get beyond the law part. They're getting the hook. All right. Thank you all for having me. I really appreciate it.